Good news out of the Supreme Court today, and it has to do with campaign finance reform. When was the last time you heard that? Now, specifically in this case, it has to do with judges and whether judges running in judicial elections in states that have them should be able to solicit campaign contributions. Now, currently, out of the 39 states with some judicial elections, 30 of them bar personal solicitations of campaign contributions in order to preserve judicial impartiality. So we have a case of Williams-Yulee versus the Florida Bar. This was in Florida. It was a candidate for a judicial election who sent out campaign flyers looking for money. That was against their law, so she was fined. She sued in turn, and eventually it made its way to the Supreme Court. Now, the Supreme Court, who in the past has been incredibly vigorous and aggressive in defending what they see as free speech, being money handed from one person to another, in this case, they actually voted 5-4 to uphold the ability of states to limit those sorts of campaign donation solicitations, with the Chief Justice joining the 4 liberals on the court. And this is what John Roberts said, and what is so shocking. The state may conclude that judges charged with exercising strict neutrality and independence cannot supplicate campaign donors without diminishing public confidence in judicial integrity. He goes on to say, a judge's role differs from that of a politician, and this is what's really important. Unlike a politician who is expected to be appropriately responsive to the preferences of supporters, a judge in deciding cases may not follow the preferences of his supporters or provide any special consideration to his campaign donors. Simply put, the public may lack confidence in a judge's ability to administer justice without fear or favor if he comes to office by asking for favors. And that makes a lot of sense. Imagine in many of these states how cheap it would be to buy a judge and how important that could be in terms of influencing how that judge eventually rules on cases having to do with either prominent individuals in that area or when it comes to regulations on corporations and things like that. And so I think many people will be able to understand what John Roberts is saying there. What they may not understand is why he doesn't then take the leap from that to understanding why politicians might be similarly influenced by campaign contributions. If a judge can be influenced by $1,000, then how does a politician accepting millions of dollars in many cases from individuals or corporations, having to then balance that interest or that influence with the interests of hundreds of thousands or millions of the people living in his district or in his state? That doesn't seem that hard to understand, how they could be corrupted in the same way that judges could be. And if you believe the one, I don't think it's crazy to think that you should believe the other as well. That said, this is still good news, and while I continue to believe that a constitutional amendment is the only viable path to getting money out of politics, if on occasion the Supreme Court wants to act right, I'll take that too. And that's my final judgment.